Absolutely, guys.
Hey, everybody.
Hi, everyone. Welcome to Forensic Intent.
We realize that things are going down in Baldwin right now, and here we are live. So we appreciate you being here, but you can always catch the replay. So please like, subscribe, set your notifications. We have the amazing Josh Schiffer back with us. Yay!
Hey,
You're gonna get like a purple jacket when you hit 5 appearances on our show.
I've got it nearby. You know, I've got a couple now, and we are
the robe. We'll
just as kitties are wandering around left, right, and center. We're going to get one here right now. They hear your dulcet tones, and they're like, "What's going on?" Yeah, it is kicking in Baldwin, and we're still fooling around with this Reed case, which I just read something. I've been in court a little bit this morning that there was yet another supplemental filing, maybe sometime today from
the Commonwealth responded.
Okay.
I don't know about the another like it was confirmed that the foreman was a guilty verdict on the charge they deadlocked on, but it's allegedly the foreman confirmed this. I don't know that this is like totally true. I'm just saying allegedly.
No. This is all as it happens, speculative.
Right.
Mm-hmm.
The foreman. What I see out there is that the foreman said, yes, correct. We were only deadlocked on the one charge, and I was a guilty vote. So,
and it's such a fascinating thing because, all right, so when a jury comes back, like it happens, this isn't like the first time. We always have to say, who here doesn't know what an Allen charge is? Because really, we've seen this before. Mm-hmm. And Judge Beverly Canone didn't really be a good judge at that moment. Because where I'm from, and I practice primarily here in Georgia, I'm barred a couple other places, but really my trial experience is almost all Georgia. I help people in other cases, but this is something that kind of is just regular. If a jury comes back with questions, the judge reads the questions, they figure out the answer if it's not an apparent answer, and they all send it back as a group. Now, when a jury comes back and says, hey, we are deadlocked, and after a couple of deadlock notices, the judge almost always does the Allen charge, which in Massachusetts is, I guess, the Tui Rodriguez charge or something like that.
Right.
And basically that's telling the jury, hey, y'all, you really need to put everything to the side and come to a decision. If you don't come to a decision, we're going to have to stop this. And when the jury comes back and still hasn't made a decision, that's really the end of deliberations. But the judge can and should inquire as to what's going on. And that just didn't happen. And I can't tell you if that's regular in Massachusetts or if that's something that I'm just one of them crazy guys from Georgia. But from what everybody I'm seeing says is, whoa, Judge Canone should have stopped, done some basic inquiry. And now we are facing this kind of unprecedented post-dismissal collateral attack on an indictment that is theoretically still active. When they mistry a case, that indictment still is active. The case still exists, and it's ready to be tried. So there's this argument. Has a decision been made? Well, no, because the judge didn't issue any kind of a verdict. There was no polling. But now we're getting some extrinsic evidence coming in that appears reliable. Their affidavits. This is all here. Guys, that doesn't matter. You got to understand. This is not somebody off the street saying, hey, judge, this is the lawyer. This is someone whose butt is on the line.
Yeah.
And for them to come out and say something, it ain't a lie. It ain't a lie. You ain't going to lie like that if you are trying to, be unethical. That's a dumb lie. It's easy to bust. It's easy to verify. And so Jackson and Yannetti coming out, filing these very straightforward allegations, say, hey, they came to verdicts on 2 of the 3 charges. Judge Beverly Canone just didn't go record. That's tough stuff. And more appeals, more work, more bandwidth sucked up, other cases getting pushed to the sideline. That's really the optic that a lot of people care about. Because this case, come on, it is snake bitten. And I know there are some content people who are like, oh, can't wait for the retrial. I'm banking on If you're a DA, are you retrying this case? If you're one of the other officers, do you want to try this case? If you're one of the witnesses, do you want to retry this case? And if you're anybody with the state, do you want to go through this torturous? You're going to get excoriated from what Trooper Proctor did, and that's done.
Yeah, that's the thing, Josh. And that's what I was going to say. Is regardless of whether they retry it or not, you still have the same crummy investigation and all the stuff that went on.
That's exactly it. And I'm like, listen, who retries it? You get Lally going up there. He's not gonna have his heart in. I don't care how. No, man. Guy had to go up there as a professional and work his butt off on a case where they handed him a file full of dog poo. Like,
I hope he has a good therapist.
Honestly. Oh, no kidding. People ask who I feel for, and obviously I feel for Karen Reed and John O'Keefe and all. Lally, to me, is this tragic hero. Here's a guy who probably is a really nice guy trying to do his prosecutor gig. He's been a prosecutor there forever. He gets told, go try this. Yeah. And he looks at it, and then he's got the entire world attacking him.
Yep.
In a way that I don't know of another prosecutor that's ever withstood that kind of public ringing. Like,
I don't know. I mean, Kirk Nurmi went through it in the aftermath, and I mean, he could probably reach out to the guy.
It's just not like when you talk about excoriate, his name was in every paper for 500 miles. Yeah. He had I can't probably walk down the street without, hey, can't believe you boned the Karen Reed, or hey, can't believe you prosecuted Karen. There's no win on either side.
Right.
And he had to deal with what he was given. He didn't get to choose that case. And arguably took some marching orders from Morrissey and some other people in the establishment. You got to go prosecute cop killings because you kind of do.
Yeah, yeah.
But what a absolute mess. And I think it's going to be fascinating to watch what happens. And now we also have the whole other people involved cases were apparently moving through the universe yesterday. So I paid attention a little bit of that. The intersection of content creators and the justice system when it comes to these high-profile issues. That's a fascinating story.
Pretty interesting for sure.
New stuff.
Well, I've spoken to prosecutors, and there's a deep value in community engagement because that's how they discover new witnesses. That's how they discover people outside of how investigators. That's why cops walk the beat. So you get to know your community. It's good police work. It's good prosecuting. But this one's gotten sideways. And you have this Turtle Boy guy who is a known adjutant. And I love freedom of speech. And I love adjutants. Heck, I've represented a bunch of them. But personal responsibility comes into some of that. And you can be an adjutant, man. You don't have any special immunity. Calling yourself a journalist or a blogger or what, that is not a shield. They don't suddenly, when the officer shows up, oh, he said he's the press, we should stop. No, man. That ain't the way that you've not attended very many riots if you think that's
yeah, exactly.
True.
No kidding.
So some of these allegations where I'm from, you go to jail. Like you go jail. You don't get here's some probation. No. You can't follow rule. So stalking and these kind of intimidation things, there's the catalyst that's causing whatever the interaction. And sometimes if you extinguish that catalyst, like the Reed trial being over, then judges will treat the case and, all right, we're all past this. Can't we all just be nice and be friends? And no one needs to really suck up any law enforcement resources with a simple first offender probation, stay away from each other. But this ain't that case. This case is still sticking around, and that's a big problem. The state or the Commonwealth has a lot of reasons to be very interested in people continuing to be involved in this case in a way that affects the substantive interests of justice.
You're right.
It's interesting for sure. Yeah.
Josh, brief us on what's going down in Baldwin right now.
Yeah, Baldwin right now.
Those who haven't watched.
Yeah, Baldwin right now.
Witnesses.
It's cooking. So we picked a jury early this week, and it all went really smooth. There is no love lost between the prosecution and the defense. None.
I'm having fun watching that. I think it's hilarious.
They are so restrained. It hurts to watch. Like, they are white knuckling anytime they have to interact with each other. I hate to think what the other channels of communication have devolved into. And so trial starts. It was not a bang up, big Hollywood style opening. Bluntly, the state was reserved and clinical. And I think that was a smart choice from them. The woman who is prosecuting the state's case has a very distinct and clear personality. She's a very professional prosecutor. She is not turning up the heat on the emotions of Hollywood or in it. No, she's trying to stick straight to the facts. Hold on just 1 second here. I'm really busy right now. Thank you. Oh, yeah. If you're done, just pack up and shoot me a bill. All right.
The carpet cleaners.
Oh, okay. Hold on. Just come on upstairs and I'll give it to you.
They just switched witnesses.
Put him on the show.
So, no, it's my carpet cleaner. I
know. Put him on the show.
Had my friend. We can ask him. So they start the case. They start the trial. The openings are not what I would call explosive. They're restrained. The state did a very reasonable job presenting a straightforward, people have violated the law when they point a gun at someone, pull the trigger, and someone dies. It's a good argument.
Yeah,
it is.
I thought they did really well laying it out.
There's a whole bunch of, there's a theater, and no. If you have a gun in your hand and you point it at someone and they die, that's criminal. And I totally understand that. But at the same time, we've got all of the actor issues involved. We've got all of that. Here, you can come on back here, man. We've got the actor issues involved. We've got everything on the set. We've got the 2 other people that have been convicted in this crime already, which is a huge, huge deal. The fact that there have been 2 prior convictions, 4 responsible parties, 1 via plea, 1 via trial. To me, if I'm the defense attorney on that case, I'm talking about that the entire time. Yeah, everybody gets a day in court and the state found their man. The person who's responsible, they've been convicted of crime. And Alec Baldwin, there's so many different plays for this. He can lean into, you're only prosecuting me because I'm a celebrity. You messed up the prosecution once and you're only going after me because you're a headhunter. And I think that juries totally understand the headhunter aspect. The juries absolutely love. Hold on just 1 sec. Here we go. Much obliged, sir. Thank you. Juries absolutely will understand the headhunting, but at the same time, they will understand the flatness of the state's case being how straightforward pointing a gun, pulling the trigger, causing a death is. So I believe the jury will eventually focus very strongly on the jury instructions. And I don't know, we discussed this last time. I don't know whether it's a community. Thank you so much, sir. I don't know whether it's a community that publishes the jury instructions back to the jury, or if it's like most jurisdictions where they just read them. And we see time and time again, just like Reed, just like in so many other cases, where a less than full understanding of jury instructions causes jury confusion. And when you get a confused jury and lay that on top of the fear of wrongful conviction and the fear of wrongful acquittal, it makes juries really hesitant to be firm. Because they've got to come to a decision sitting in that room. And the way the state's putting it is, hey, you idiots, it's a crime to point a gun at somebody and then pull the trigger and then have them die from a gunshot.
Right.
It is. And you can call it reckless. You can call it negligent. It's crime. and it's that very stark approach. We talk about the reptile brain a lot in law for the last 15 years. There's a series of very influential legal books called the reptile theory that involves your most base, built-in, absolutely hardwired into your soul and existence, inherent feelings such as fight or flight, your instinctual beliefs that you can't cognizantly change or affect. You can see when they're happening and maybe affect your decisions. But if I threaten you, you're
medulla oblongata.
Yeah. And Doc, you know all about that. It really, the layers of cognition and understanding what's going on. If I get to a basic threat of well-being, if I'm going to disrupt the rules that you run your entire life on, fight or flight, self-preservation, things like that. If I can access that, I can choose you to pick left or right on your pathway by focusing on some sort of fear, because fear motivates more than anything else. So the reptile theory would be setting up that rule and then showing how the rule was violated in order to get someone to vote on your or towards your position. The state in this is scaring jurors or motivating juries to vote for conviction by saying, if you don't convict, you're saying it's okay to point guns at people.
Right. Yeah, I get it.
Yeah.
Hey, man, I'm a juror. I go, I don't want to be remembered for that.
Exactly.
I don't want to create that kind of case law and precedent. And at the same time, the defense can use that same polarizing and reptile theory to say, if you don't protect Alec Baldwin, the danger is to, I don't know, we can just pick art. You're destroying art. And that's another motivating fear for a jury is, hey, if you listen to what the state is trying to do with its criminal laws, they're trying to crush creativity and movie making and theater and everything important by nitpicking and cherry picking and creating this very complicated, reckless behavior pathway that no one's really going to understand. It's going to be so complicated, and you, jury, you're going to be the ones that allow that to happen. And that's a fear that some people will connect with. But that's still going to develop. Now, fast forward to what's going on today.
Yeah.
This was out of nowhere. Trial's just kicking along. Great old trial. Get some witnesses up for the state, and we're listening to them talk about what happened on the set and how the gun had its post-firing destructive test, because the defense has very much harped on the fact that the gun during the testing performed by the state authorities was eventually dismantled, destroyed, or at least caused to be in a condition where it is not able to be examined by the defense.
Correct.
And during that process, came out of nowhere today. I believe it legitimately was a surprise to the state. From the way I see it, because I don't think they were actively hiding it. But a third party showed up, gave some state workers some other bullets that were of the type, nature, and associated with the same lots as the bullets from Rust. And along with that was some sort of information about how there might have been a plot to have people involved in the armament and production of the film fired. And a way to do that, if you're trying to take out an armor, is obviously throw a blood bullet in there.
Well, there you go.
100%.
It sounds fantastical, but guess what? It's a workplace dispute. There are no rules with workplace disputes. People do the most ridiculous things at workplaces. Think about every one of those, a diner where somebody put poison in the spray bottle or spit in the food. There are so many different things. I've had race cases where literally adults posting the most offensive, hateful, awful materials where they work every day.
Yeah, this is why I work alone.
Yeah, like you see this stuff and you're like, I don't play well with others like that.
By myself.
I'm my own boss. I only have one other person. Like,
exactly.
People will do bad shit, crazy things in a work situation. So is there another armor that could have been jealous of the armor Hannah, whose father, remember, was this really important arm?
Right.
Bad blood flows, especially in such a tiny universe as armors for
such a niche.
Hollywood.
Yeah.
I'm talking about 60,000 of them in the United States.
Right. And how many work on actual big films with big actors?
A-list. This was not my, film school project. No.
Right.
These folks got paid big money. If you hear them talking about when they're moving stuff around and going, they are reserving camps in states to put up a training camp for actors, dozens of firearms, hundreds, if not thousands of rounds of ammunition. Then they're talking about packing it up, bringing these firearms across state lines to other films, all the insurance. That's a whole business. It's a big operation. So the idea that someone's out there hating on the daughter of a prominent, I buy that as being 100% possible.
Sure.
And what basically the motion that's happening right now is about, did the state know about these bullets, which were classified separately, placed under another case number, not included in the discussion at all? And what about this information about this plot against Hannah? That is exculpatory information, without a doubt. There's no question. If someone tells you, hey, there might be a plot that would completely explain how this mysterious accident, man, that's super relevant. And the big case that everybody's been talking about is Brady versus Maryland, the seminal 1963 United States Supreme Court case that places the obligations in discovery more on the state than anyone else. Because the state's the only one the cops will talk to, because the state's the only one that has labs, because the state has the investigation. Believe it or not, when you are being prosecuted by the state, the majority of your evidence is produced by the state, from the state, and and everything's complete on their honor. And it's the on their honor part that gets real sticky, because the state has a continuing obligation to keep providing that information. Late arriving information, it's not excluded. If the state learns of exculpatory information, they have an obligation to share that immediately.
Yeah, they do.
And it's a big deal. So the state also is treated as one giant organism. And an officer can be given some information and not handle it well, and that not handling gets attributed to the prosecution later on. So over generations of litigation, the Brady obligation has been picked apart in various states. It's a federal holding, so the states all have to interpret it themselves. And over time, prosecutors have picked at what is required, what their obligations and duties are. So the state's gonna come back and say, if we didn't know about it, if it wasn't included in anything we're going to have under our purview, we couldn't have given it to you. And therefore, your whole motion about how we're monkeying with justice, it's just baseless. Let's go on and keep trying this case. But that Mr. Spiro made a very solid, clear argument, emotional and authentic, at the beginning of his motion, where he said, Judge, it's not just this. This case has been tried aggressively by all sides. And therefore, we've got the list of other issues that the remedy wasn't what the defense asked for. Because the real remedy the defense wants is a dismissal with prejudice attached. Prejudice attached means that the state can't go back and try it again. It's really held against the state. It's because the state made a mistake that the judge is saying, you can't try this case. You failed in your duty to go obtain justice, and I'm taking away the state's ability to prosecute this case again because their mistakes were that egregious. That's a big remedy.
It's a big deal.
Yeah, it's a big deal.
There's no come back there. No, it's gone. And very rare for an appellate court to disturb a trial court, because remember, the appellate courts, when they review trial courts, the initial is we trust the trial courts to do what they're doing.
Yeah.
We're here to make sure they didn't screw up really big. But we can't possibly know what happened. That's why we have a transcript, and that's why we rely on the trial court. So courts of appeals are not going to disturb a remedy such as dismissal unless there are really foundational issues where the trial court made a mistake. And I don't think that would be the case when the defense knows about discovery and evidence that the state either didn't know about, and regardless of knowing or not knowing about it, never provided when it's clearly exculpatory. He added that to the pile of multiple other issues that the defense has brought up, asking for a mistrial. And this may be the final part that crashes the wave. And the judge may have to turn around and go, listen, I can't let it go on anymore, because she's also looking at a future appeal. All the issues they brought up in the past 3 days and whatever happened, or 4 days and whatever happened in the pretrial motioning, that's all sitting out there as potentially appealable. Now we've added several more issues just in a couple days of trial. If the judge sees that, she can make the call. Listen, it's just totality of circumstances. There's been too many issues. It's now gotten fundamentally unfair for the defense.
Wow.
So that's where we were. And
what do you think what do you think? Do you think, I mean, obviously it's very rare. What do you think? Is this, if you had to predict?
I want to know more about what actually happened with these bullets in the exchange. The state smartly is going to try to make it a careless error. Careless errors, errors can be categorized by appellate courts where the error, if it is not substantive, it's called literally harmless error. That's the legal term of art. And it says, yep, court screwed up, broke its own rules. That's bad. But it doesn't rise to the level that it would change anything with this case.
Okay.
Right.
Yeah.
That's the general, if there's a careless rule, how the courts kind of whitewash over an error or mistake. Now, clients don't understand that. Clients hold the courts to, and the public holds the courts to a high standard. If you violate the rules, there are consequences. That's not reality, though.
Yeah.
Rules get violated in court in every trial.
But when you talk about substantial, even in the defense's opening statements mentioned, the big question here is how in the world did these live rounds even get there? And if this is evidence that could point to potential things that need to be investigated, that need to be looked at, the defense should be able to figure out if it's legit or not. That's a big, this could be the answer of how they got there, right?
And let me throw this on. That's a great issue to talk about in front of a jury if you're trying to get a jury to doubt the legitimacy of the state. And that's a major theme of the defense. This is an illegitimate prosecution because they've already got 2 people convicted for the crime. And then they tried to charge them. That was a dumb effort. And then they basically redid everything to try to get a second bite at the apple. Artfully, you could present all of this cacophony of weird actions from the state, non-traditional, combined with the Hollywood, and make a real cynical juror out of that.
Yeah.
Like, just really I don't trust the state is a position the state lost over the last 20 years or has gained over the last 20 years. People don't trust the state like they did 20, 30, 40 years ago.
Yeah.
We're much more likely to question the motives of law enforcement as well as their fidelity to policies, as well as their motivations, in a way that at the beginning of my career, we never could have asked or expected a jury to understand that perspective.
Yeah.
Now, look at that. That was the Reed case. You never could have gone forward with a conspiracy like they did without a cynical jury pool who seen bad stuff come from state agencies and state actors.
Yeah. Mandy, yes, you're right. That's part of what the defense talked about in their opening statements, though, is, the rules of gun safety are different on the set because in order to create the scene, you have to be able to point the gun at someone. You have to be able, and he was just doing, and there's even notes that they found that he was doing what the notes said and what he was being directed to do is pull pull the gun the way that he did. And so, yeah, he was practicing that scene, and yes, pointing the gun at someone, but out in the real world, yes, that's problematic. But when you're at
oh yeah, well,
you
and you can look
You're
at
not
firearms training in other situations for how this is dealt. There are blue guns
Right.
and red guns in every officer training. You're not actually using your sidearm. You're using this
Right.
big, very clearly fake plastic gun. Movies can't do that.
No, they use real ones.
Yeah, it would destroy everything. To follow the theoretical rules of gun safety, that would destroy the ability to have genuine entertainment. It conflicts.
Sure.
I think that's an interesting exploration that makes jurors think about detrimental reliance on the armor by the actor. And by that, I mean, if you're the actor and you're handed the gun by the person whose job it is to make it safe, that should absolve you, right? But every time I do that, I go, well, Josh, you've handled a whole bunch of firearms. Even if someone tells you it's safe, you check.
Yeah.
And with a rifle or with a revolver, that's very easy. The moment you get into firearms where, and this is what I really think about, semi-automatic, clip-based, magazine-fed firearms, you can't check every bullet.
Not at all.
You got a magazine with 10, 30. They're drum magazines that hold 100, and you're doing multiple takes.
Right.
That's why it's one person's job to be sure before they hand this over to you. Yeah, because an actor can't sit there and check. You're exactly
And then
right.
we get into transference of criminal liability. So here's my hypothetical. Scott, you and I are roommates. It's, 1874. You and I are in undergrad. It's the first day. I meet you. We're cool. We're meeting. I'm like, hey, Scott, how's this? All right, so we're lifetime buddies. I'm going to commit a bunch of financial fraud. I know that's fraud. We're going to make $1 billion, and the maximum fine is $100 million. But I'm probably going to have to go to prison if I get busted for like 2-3 years. I need a partner. Scott, we're going to break the law, but we're going to get rich, and the punishment isn't that bad considering how rich it's going to be. So how does that criminal liability work? Have I transferred it to Scott? What does Scott do or not do? Can I sell criminal liability, such as if I'm paying someone to go murder someone versus transport drugs? How guilty is the person? How guilty can someone be if they know they're violating the gun safety rules, but with no expectation of the trauma that could flow versus it just, you start playing those games in your mind, and you can reposition your perspective a lot of different ways. That strays you away from unanimity and a conviction.
Yeah. It's really interesting. My wife and I were talking about this case yesterday, Josh, and she related it to nursing because things happen in the OR a lot. People get the wrong medications. It just happens. Okay,
stuff happens.
And she equated it with Alec Baldwin. She equated it to, she as a nurse reaches for a certain vial of meds for the patient and thinking that it's because it's labeled what is needed for that patient. It's the medication that's needed. And yet the person that stocked that vial completely screwed it up. And, so she gives the medication, the patient crashes. Is she responsible for it? Or is it, you see where I'm going with that?
And you get into the really ugly gray area of civil versus criminal. And we know that there are civil suits that are going to be super duper successful. There's a lot of money that is going to get paid because this was absolutely negligent and wrong and injuries flowed. And there's no question in my mind or any other lawyers that there's going to be huge civil damages. There's no question about the criminal damages for the people whose job it was to manage the armament. No question at all. When you start extending that out, you really get, Schiff happens.
Yeah.
If you do the same thing every day. This is the 9,000th person Alec Baldwin has shot on film. Think about Bruce Willis.
Oh
Think
man.
about Arnold Schwarzenegger.
Yeah.
How many people has Arnold Schwarzenegger blown away? I guarantee if you said, hey, Arnold, you check every time you pulled that trigger, make sure that those bullets were blanks and not real.
Right. Nope.
Does not pass the straight face test.
Yeah.
No.
At all.
No.
If you were to go pull 100 Broadway actors who have shot thousands of bullets in the middle of crowded theaters in Manhattan, hey,
Right.
So do you check the gun? Like, I know that it wasn't in this scene and it's sitting over there in the corner where somebody could get it. So gun control rules would be the moment you pick it up for the next scene, you check it. That's never happening.
Right.
Never.
Right. Yeah. Well, Josh, there was a lot of talk earlier today. I was watching several different live streams today, and there was some talk about a plea deal potentially being offered to Baldwin. And basically, you pleaded this. You don't do jail time.
Yep.
And you keep your act together for XYZ amount of time, whatever they deem, and the charges go away.
Yep.
And would not surprise me.
Absolutely. Strong possibility. Depending on, of course, how this motions hearing comes out. And the worst part is the state, if they really want to get aggressive, and there's no reason they wouldn't, they'll start making the offers while the decision is pending.
I see.
That's a regular lawyer trick is, hey, judge is going to go back there and figure out what's going on. You want to strike a deal right now? Talk about a hard deal to effectively evaluate. Were your arguments good? Were your arguments bad? Did the judge like what you were putting down, or did the judge reject it? Can you read the judge efficiently? What was in the written materials? Do we know whether the judge is going to value written over testimony? It gets really scary. And if you turned around Alec Baldwin and say, hey, Alec, we'll give you disorderly conduct for failure to appropriately manage the set, and you get a year of probation and take a class and pay a fine.
Yeah.
Hard for me to tell a client, no, man, risk going to prison. Especially if you
that's pretty tough.
It's the regular result of what we call charge stacking here in Georgia, and it's everywhere else. They can charge you with 10 things, even though you only did one thing. So you're facing 900 years, and the decision becomes, hey, do you want to risk everything, including 900 years, to stand at what's for right, or they're going to offer you straight probation as a guarantee? Yeah. It's really hard for me as a lawyer, knowing how jurors have gotten it wrong before.
Oh, absolutely.
Get it wrong again in a system that I can talk about the problems in our system all day, and our system's filled with people trying to make it better and have less mistakes. It's not perfect.
Yeah.
You gonna risk dying in prison versus probation? Hell no.
No way.
Not in a million years. Same with Reed. Everybody's talking about reach up. Hold on. They walk up to Karen Reed and say, hey, we'll give you a misdemeanor DUI with the standards.
Yep.
Yeah, you take that.
Oh, yeah.
Financially, she's going to spend what, another $250,000, $500,000, $1 million? No, you pop that DUI plea just like everybody else does. And you go to sleep going, man, that was unfair, but had to do it. It's why we literally have a kind of plea. Some people we've discussed, I think, on this show before, Alford pleas. Alford versus North Carolina is a seminal case out of the United States Supreme Court. It's hilarious, but so operational. Alford stands for the fact that you can plead guilty, say that the state has lots of evidence, enough evidence that they'd be able to convict you, and you're willing to get sentenced and plead guilty, but you still didn't do it. And it's literally
insane.
When you hear the recitation on full, you go through. Yep, I understand that the state has plenty of evidence, and it would be likely for me to be convicted. But I did not do this. But I need to plead guilty because the likelihood of me being convicted is so high, and that would be a material negative impact on me.
Yeah.
And that is
the
how
suitcase guy and the West Memphis 3. And I put myself in those, not in their scenarios, but in the Alfred police scenario, and it's just, I can't wrap my head around it. It's so tough. I get why people do it.
I get it for operationally, it's the last thing that gets your client over the plea threshold.
Mm-hmm.
Because you'll have people come in and tell you a million ways. Didn't do it, wasn't even when you are, because a lot of what I do is reality check with what I expect the state to put forward. Because that's the information I have from the state. Hey, that police report, I know we disagree with it. That's what the officer is going to testify to, though. Like, that's really the purpose of review it. Right. That's what the state's going to present is in their discovery. And you review it, and the clients will sometimes just take farcical positions that are impossible to prove if we were going to go to trial. And they are just, standing up, not thinking very clearly. And Alfred is what you spring on them at the end when it's close, but it's not done. And your client has legitimate concerns about pleading guilty to something that they didn't do, or they didn't do it in the way that the state alleges, which is very common. Lots of times you get clients going, man, I did like parts of that, but it wasn't like that. It's like parts of it seem pretty criminal, and we can. I don't
like
care
Sarah
Boone. But it's part of the conversation, and you bring it up to the client and say, well, listen, if your fears manifest with, going to trial and risk reward and those fears, how about we snuff one of those fears by addressing your principle? And people love to attach to principle when they don't have a good actual factual argument.
Sure.
It's like when people scream and yell and cuss, it's because they don't have good facts and words and thoughts. It's cheating. Alfred is, hey, yeah, I know you really didn't do this. So look, we created a way for you to carry your head high, and you can go the rest of your life and say, I didn't do it. I just took the plea because my lawyer said it was a good idea. I don't care what if I told you that's all you. You're the one that stands up there and answers the judge's questions. I sleep very well at night with clients that have said, I'm innocent and I'm just pleading because, yep, man, that's all on you.
All right.
Yeah.
I don't know. I just feel like I would be like, I'm gonna fight. I don't care if they said fine, send me to jail. I didn't do it. I'm gonna fight the man.
When you see how overpowering the state can be and how one-sided the state can be, it saps some of that as well as inspires some of that. I'm going to fight and fight and fight till I go down. The system evolves so that now you're not allowed to do that. I'm going to fight till the last minute. No, we've got Frank's hearings and other different ways of putting material out in front of the defendant so early that they can't, or it's much harder to play the keep negotiating until we're about to pick a jury. Because for a long time, that's literally what we did. You just kept negotiating until you were on the courthouse steps.
Mm-hmm.
And then, all right, man, let's now take the plea. Mm-hmm. And so the system has responded to give judges and prosecutors tools to speed that case up. We see an enormous amount of what are called final plea hearings. Now, you have a right to plead guilty at any point, including in the middle of trial. It's part of your First Amendment rights. You can stand and go, I'm guilty. You can say it for a jury if you really want. Because you always have that right as a defendant, the state's response has been to create mile markers where after which you lose control over your deal. And that's how final pleas work. You will go to court for arraignment, file and get discovery, go through motions, and then have some sort of a hearing, depending on your state, where the prosecutor goes, all right, we're going to put the offer on the record. We're going to put a basic factual recitation on the record, and we're going to say this is your last chance to take a negotiated plea. And if you do not accept the negotiated plea, there shall not be a negotiated plea after this date. That's a big hammer.
That is.
It's a very different situation with, hey, we in the state, we agree, we just need the judge to give us a thumbs up, versus, hey, state is going to say what state's going to say. We're going to say what we're going to say, and we're going to just trust the judge to do the right thing.
Yeah.
That's serious dice rolling. Now, sometimes it's
Definitely.
done by construction. In fact, I've got a big non-negotiated plea on a really awful death case in early August, where it is an indefensible case that is pure accident that involved the death of a young person, and it's a single car accident with a driver that had an extraordinarily narrow pathway to any kind of non-conviction. And the DA, a friend of mine, goes, Josh, we can negotiate this, but I'm never going to be able to actually offer you something that you would take. If you want to get your client's best result, you're going to go non-negotiated. And I know the judge and I know the DA and I know how this works, and they're right. The best way for me to get justice for my client is on the day where the judge is going to have sole and complete discretion to pick a wide range of years in prison. How do I go and get the judge to give me what I want, which is just a little bit of prison?
Yeah.
You can also ask for no prison. That's just not necessarily the wide ask.
It's not 0 to
No, man, I want
25 years.
It's like, no, your actions resulted in the death of a child. No one's giving you straight probation.
No.
But you've got to set it up like that, and hopefully curry the relationship with the prosecutor so that when the prosecutor gets up to do their presentation, you don't want them to go scorch earth. You want them to softball it. You don't want, you can get benefit for your client by working that relationship with the DA and say, hey, yeah, I'm not going to make you work your ass off and fight. We're going to take this high road, and it's a different way of negotiating and getting the disposition that you want. And ideally, we're going to get my guy to have a short prison sentence that clearly he has the message, but preserves his ability to be a successful person for the rest of his life.
Very interesting. Yeah. So, Josh, Mandy has a question here, talking about no contest versus, pleading no contest. Her question is that the same as guilty?
Yeah, and so the way that I explain to people is no contest is a criminal notation that really only matters in civil law. No contest means that you are not contesting the allegations as made against you. You're not pleading guilty.
Right.
Guilty means I did that. I violated the law. It is an affirmative statement of culpability.
Yeah.
Right.
No contest is, I'm not going to fight about this. I'm just going to take the punishment and run. And that's why, even though it applies to a wide range of charges, most of the time you see it in things like traffic, where it's non-intent based, or sometimes intent like speeding. But what you're really looking for is to limit the impact on other proceedings associated with the violation. And that's why you see it a lot with car accidents, speeding, anything where there's some sort of civil injury action. Because if the case was disposed of through no contest, you can't use it as an admission in the civil case to prove liability.
Okay.
And that's why you have a very limited usage of it. In most states, you can only use it so many times within a period of time. And in most states, if you plead nolo contendere on traffic tickets, the big immediate benefit is no points. And it prevents points from being assessed against your driver's record, which keeps your insurance rates a lot lower and also prevents them from suspending or affecting your privilege to drive.
Gotcha.
Not a guarantee. There's a lot more digital information out there than ever before. But it certainly does have some real value. And in certain cases, it's a very litigated subject, notably big injury cases involving automobiles and trucks.
Okay.
That makes sense.
Thanks for answering that.
Absolutely.
So I'm gonna shift gears for a minute, Josh. We've got some people in the chat here that want to talk a little bit about Sarah Boone. Are you? So let's talk about including Rachel.
Always want to talk about Sarah
So
Boone.
yeah,
Where do you think her mind is, Rachel? What do you think her diagnosis from the armchair is?
Oh gosh, don't make me diagnose her, but because I really hate publicly doing that. But
do you think she is incompetent from a visible? Just look at her, interact with her. It cannot help it from bad.
Oh, incompetent to
like
stand trial?
Yeah.
No. I mean, there's one part of competency evaluation where I suppose, I mean, you couldn't pay me enough to say this, but maybe there would be somebody that you could pay that would say that her personality structure is so damaged that she is not able to effectively cooperate in her own defense with her attorney. That would be, so that's a portion of, competency. We ask them about, like, what's a judge, what's a jury, what's the role of the defense attorney, what's the role of the prosecutor, and they have to be able to understand these things in order to be competent. And one piece of that is, can they meaningfully participate in their own defense? Can they get along with their attorney? Can they understand that their attorney is defending them and is in their best and working in their best interest? And so you could spin it that no, but that's typically reserved for people that are with lower intellectual ability, people who are actively psychotic, paranoid, delusional, not typically the severely personality disordered, because because
the competency issue comes up because it's so extreme how the lawyers won't work with her.
Oh, it is.
I haven't seen the yelling, cursing, unregulated behavior, psychotic behavior, evil behavior. She's not covered in tattoo. No, she's not displaying some antisocial, immediately visible manifestation. As much as what we do know is that no lawyer will work for her. And not just that, lawyers that were told in advance about the challenges went in with the widest eyes only. And they're not just picking these lawyers out of a hat. No, they need a lawyer to stick. So they're vetting these lawyers.
Yes, I think they are, and I think that she is competent enough to know how to work this system.
And that's what we're getting at.
I don't think that this is purely I can't work with other people. This is I'm going to make it as difficult as possible to work with me, because I would way rather be in this dormitory style jail with other women who can kind of hang out and it's low key, as opposed to an isolation life in prison, situation. There's a big difference.
She knows enough about the system to be able to effectively stymie it.
Yeah.
And I believe you're absolutely correct. She knows certain ways to destroy a lawyer-client relationship
because she's done it.
No turning back. Exactly.
She's done it with her boyfriend that she murdered. She talked in the body cam video, the day the police came and the ambulance got him. And she talks about how she did everything for her boyfriend legally. She was like a case manager for him and his legal troubles. She knows how to navigate all of this, and she knows what to do. So
So what does the court do? It's absolutely rare. It never happens, even though it's possible, for the judge to do what she did, which is remove your ability and right to access counsel.
Yeah.
It is clearly going to be appealed a million different ways. There is a set of cases out there basically in every state and jurisdiction that guides to some degree the extraordinarily obstreperous but competent client. There's a lot of different cases, both federally and state, that have explored the different ways of dealing with that. I believe the judge is taking the appropriate tact, which the judge has an obligation to try the case within a constitutionally permissible period of time, and that's gonna happen.
There will be an attorney there for her to consult with during trial, correct?
I wonder how that works, because standby counsel, just when you're assigned as a lawyer for someone that is not cooperative, there's some ethical guidance as to what you can or cannot do, but it's low bar. It really, you're an emergency life ring if stuff goes really terrible for the client to reach out to. But different lawyers are going to approach standby counsel very differently because it's an exposure for that counsel. It's very dangerous. You don't want to end up in habeas court for the rest of your life for mistreating a client, even under the best of intentions, and helping people who frustrate all attempts at assistance is really challenging. Now, it's worth it. It's great. God bless the people that are willing to put themselves in that kind of crosshairs. But there's a distinct risk and danger to performing that kind of legal work.
Yeah,
I believe that the judge will assign standby counsel, but the judge is going to make this case go forward. And that means the judge is going to be preparing for a aggressive pro se trial. And we have all seen some pro se trials.
So here for it.
Love them. It's the ultimate in American exceptionalism and specialness. You have that God's right of creation to appear and speak on your behalf. Even if it is an absolutely terrible idea, there's no guarantee of making smart choices. But I would expect the judge to move forward on a very explicit and firm pathway with open and firm dates. It's not going to get disrupted. The judge is going to crank down on Miss Boone's ability to disrupt. It goes back to the kind of Darrell Brooks universe.
Yeah,
exactly.
She's not going to follow the court's direct instructions.
No.
The court is empowered to manage its courtroom with a lot of discretion. And we'll see what kind of touch the judge has. And we'll see how Miss Boone reacts.
She'll be so whiny. It's going to be
She
so
will
whiny.
be. She's going to be very difficult.
I don't have this. I don't know what. I don't have that.
I
think
ma'am, you're responsible for preparing this. You no longer have counsel. You're aware. If you're not prepared, we're going to rule on what you're not prepared on, and you can appeal that later.
That's it.
Yeah, it has to be like that. People like this need boundaries that are unwavering. She can't be allowed the leeway that Darrell Brooks was allowed. She can't, because it will be circular.
Well, and the judge has this weird position where you got to ensure their fundamental rights have been met, but that does not include protecting them.
Right.
Like, the judge is there to ensure rights are able to be exercised and that you get the benefits of those rights. But the judge is not there to protect you from your own decisions.
Right.
In fact, it's kind of the opposite. The judge is there to evaluate and consider your decisions in the context of the state making a criminal allegation.
Yeah.
And very quickly, the judge will establish some accountability on a pathway where, all right, Miss Boone, if you interrupt again, this is what's going to happen. All right, this is your 4th time that you weren't ready for this. This was the 6th time we've told you this. If you can't do that, I owe this jury an obligation and duty. I owe the state an obligation and duty. I owe the taxpayer an obligation and duty. That is to perform a legitimate trial with integrity and get a verdict or disposition. And Miss Boone, if you choose to not participate, that is your choice.
Right.
She's had plenty of opportunity to alleviate that anyway. I mean,
yes.
Yeah, she just has. So, it's kind of backfiring on her a little bit, Josh, if you want to look at it from that perspective.
You're absolutely right, Scott. That's because you can play around FAFO. You can play around for a bit, but people are professionals.
Yeah. And this is by definition of personality disorder. This is what they do. I mean, and they end up sabotaging their relationships and circumstances in every aspect of their life. So this won't be different for her.
Without a doubt. Yeah. This is, I believe that people with experience working with people exhibiting these kinds of imbalances will agree with the court's assessment that, yes, she is legally competent, but she is not acting in her own best interest. She is going to make errors that are going to harm her And guess what, society? She's yours. You are the safety net. The criminal justice system is the safety net because the non-criminal system didn't regulate her to the degree to prevent a death.
Right.
And therefore, she needs more regulation via the criminal justice system, and her behavior during this trial is probably going to justify a stiff sentence.
Yeah. It's like, the competency situation when we do evaluations for people for medical competencies. If they have an illness that requires a treatment that's particularly horrible, and the patient is like, no, I don't want treatment. I just want this to kill me. Like, I don't want treatment. And so family members, because they're distressed, he's not in his right mind. This is a terrible decision. Like, why isn't he accepting treatment? He's suicidal. You do these competency evaluations, and to some people, maybe it does seem like this is poor judgment, but that person may have a very legitimate reason why they're choosing this for their own life. And it doesn't mean that they're not competent about it. And it's based on their belief system. It's based on, and so this is kind of like, they do have a choice to do something different, but their reasoning for what they are going to do is a different way. And so Sarah, in some ways, very kind of different example, but in some ways, that's why she's not competent. She has her reasons why she's doing things this way, and she knows there are choices to do things differently.
And it gets to the fundamental problems with competency in crime and justice. It is such a difficult concept. You can make these broad rules, but they're very challenging to enforce with any consistency. And when it comes to cruel and unusual punishment, Eighth Amendment stuff, this woman, I believe, is unable or not in a position to make decisions that benefit her. That has nothing to do with her legal competency, but my moral competency, my ethical competency. This is not someone who should be left to their own devices or should be allowed to make their own decisions. And if she had a large supportive family or something like that, I imagine they probably would have gone and had treatment, and there'd be all these extensive records and all. But guess what? She didn't. And
this isn't restorable. This isn't a restorable situation.
Well, but that's and then we get into what's restoring competence. My brother is the head of the Minnesota sex offender program, which I feel is unconstitutional, but that's a family discussion. And therapy with sex offenders for 30 years under the Minnesota scheme. I have issues with the way that we interact and the goals and how we assess and protect people that are a danger to society. And there's a lot of I don't want to call it flim-flamminess, but when you work with these individuals, each one of them is very different. The manifestations of mental health is a personal thing. And just because they're convicted or have the same set of circumstances doesn't mean their brains operate in similar ways.
Exactly.
I've met sex offenders who are so cognizant of their underlying issue, they ask for chemical castration so they don't offend again. Because they know, they are cognizant enough through their therapy that their sexual urges, they recognize, are inappropriate and wrong. So imagine the mental gymnastics it takes. Biologically and chemically, your brain is telling you to be attracted to something that logically and cognizantly is wrong and illegal.
Yep.
And if you act upon what your brain and biology is telling you what to do, you will go to prison. And how do we get those people to exist in society, and how do we deal with those people in society when it deals with something?
We could do a whole show on this.
Oh, totally.
We can have your brother on, and we can have a big.
My brother, I'd love him. He plays some bagpipes, lives in rural Minnesota, knows more about sex offendering than anyone ever. Is hilarious and fun.
We should
and
plan one near Thanksgiving so we can have a family dinner and discuss with you, and we'll eat and watch you guys hash it out. We could do that.
Just don't mention the giant family conflict is whether couscous is a grain or a pasta.
Really? It comes down to that. Wow.
What's your position, Josh?
Couscous is a pasta because it is made from flour and then it turns into itty bitty pasta balls.
Okay.
It's a very serious family issue.
That's awesome.
I'm going to reserve judgment on that one.
Written about this. But yeah, how you bring in the mental acuity of someone like Sarah Boone, the judge is going to ensure the trial is as fair as the judge can make it. That's the best thing the judge can do.
Yeah.
And Sarah Boone's rights will be trampled according to some perspective. There will be legitimate perspectives to say it's unfair for our system to put Sarah Boone on trial in the way that we do and to convict her in the way that I'm almost certain is going to happen.
Mm-hmm.
And that's very real, and it's something we should look at from the long arc of penal politics, penal planning and the facilities and what our purpose is with our criminal justice system.
Yeah.
Because as Sarah Boone, I don't believe she's going to go out and murder a bunch more people. I don't believe that that's a situation.
Maybe not a bunch more.
Mm-hmm.
But yeah. But at the same time, I don't like the idea of her wandering around the world unmonitored.
I don't
And
either.
no.
I hate the idea that we lock up this lady and we're going to spend whatever, $50,000, $70,000, $100,000 a year to house someone that my opinion is that we could handle these kind of offenders at a far more economically efficient manner through outside placement sources, community work, monitoring, lower impact, and keep them part of society, but managed. The incarceration is the solution metric. Just I'm seeing it fail left, right, and center.
Yeah.
Especially with mental health.
Yeah, we need to do a show on that because
there are doctors that would tell you just medicate her until she's agreeable, and that's the way most states used to do it. Oh, your client still is bucking up and you're having a hard time. Yeah, Judge, hold on. Give that man a bunch of lithium salts. If you take enough lithium, you're going to get real calm. Basically catatonic. Thorazine. There's so many different medicines that are basically zombie drugs that have very legitimate medical uses. Lithium is a wonder drug for bipolar. It is still, it's a very difficult medicinal regime, but it works. And it also means that if you get too much of it, man, you are catatonic.
Yeah. On that note, I have to run because I have to take my daughter to a show tonight.
Terrible person. Yeah. Oh my God, it's 5:08 already. Yeah.
It flies.
It flies. It does.
So much,
Josh.
Josh, thank you.
My pleasure. I love talking with y'all. I hope your audience loved listening to me prattle on it. And I'm sorry we didn't get to all the questions. Yeah. I would love to get I've never done a podcast with my brother. And I tell people, he's fast. Like he has spent literally 30 years with crimes.
We're going to get him on then.
Yeah, we are.
Crap. And he's the nicest, doofiest guy in the world.
I'm
that
sure.
Works with the worst people ever.
The worst people on earth.
Yeah.
Literally, you hear his stories and you're like, I can't. But we will set that up. Thank you guys so much for the invitation. I'm such a fan of the two of y'all for putting together content that is not salacious. It is not gotcha. It is a legitimate conversation.
Thank
you.
That matters. The integrity really matters.
Well, we appreciate you as well, and definitely talk to your brother because we want to get the two of you on together.
It'd be awesome.
Yes, it would be really fun.
All right,
guys. Thank you so much, everybody.
Thanks everyone for joining us. Josh, thanks again.
Absolutely.
Bye, y'all.
Bye, guys.